Good morning. I'm Patricia Van Haren, and I am here with Elizabeth Johnson. We are both part of a professional organization, Vesta, Irvine Hub, and Divorce Town USA. And the goal of both these organizations, and also the goal of Elizabeth and I personally, is to educate all of you about divorce.
All right, so we're going to talk to you this morning about the top 5 divorce mistakes and how not to make them.
And a little bit about me. I'm a collaborative attorney and mediator. I believe the courtroom is no place for families. So my office will only offer out-of-court solutions for our clients. Many people believe litigation is the only option, and I'm here to let you know that that is just not true.
While I also believe that the courtroom is no place for families, sometimes we find ourselves there, even if we don't, that's not our first choice. So sometimes there's domestic violence that gets us to court. Sometimes the other party just won't, isn't agreeable, and we need temporary orders and we need some protections. And so that's where we find ourselves. And I like to, this period of your life, may suck, for lack of a better description, but my goal is to get you through it as efficiently and cost effectively as possible, so that you can get to your new normal, whatever that is.
So our mistake number 1 is trying a do-it-yourself divorce without any type of legal guidance. We understand people want to save money. Divorce can be expensive, but sometimes doing a do-it-yourself divorce ends up costing more in the end.
Right. I mean, and one thing is, there are so many forms that are required when you do it yourself, even if you do agree on everything the first day. And, having done this for 20 years, still there are things that I learn in submitting proposed judgments to the court. And it kind of depends on the clerk you get and what kind of mood that clerk is in, and whether they reject it for the one thing that you've done wrong or the 20 things you've done wrong. And so, it's always a learning process, and it's just, I think that it's easier for someone that has done it before to do it for you.
And I found that since the COVID and the court shutdown, it's been even harder to get things through. I don't know about you.
Completely. And yes, before the clerks had a mandate where they were supposed to go through your paperwork and reject it for all of the reasons, essentially tell you all of the mistakes that you made at once, so that you could fix everything and submit it correctly the second time. But what I find that's happening is the clerks find the first thing wrong with it, reject it, and don't tell you anything else. So then you return it the second time, they reject it for something else. So it goes on and on.
It does. And also just not understanding the legal processes that are available to you, which could be best. I discussed that I'm a mediator and a collaborative attorney. So what mediation is where parties utilize a third person, a neutral person, to help them come up with agreements. I help them complete the forms and come up with a really comprehensive judgment. There's also collaborative law, where each person has their own attorney, but these attorneys are committed to staying out of the courtroom, working together to come to resolutions.
Right. And going into the courtroom by yourself is often difficult, because the court can hold you to the same standard as an attorney who's been doing this forever, which is crazy. But also, it's an emotional thing. You're going into a courtroom, maybe you have 15 or 20 minutes for your hearing. It's almost a foreign language. It happens so quickly, and before you know it, it's done. The court has made orders and you're sitting in the hallway wondering what happened. And so definitely, have a professional with you if you can, to take that weight off of your shoulders and also explain the process to you.
And our mistake number 2 is hiring the wrong person to guide you through your divorce. Not all attorneys are the same. Not all family law attorneys are the same. And so you really want to choose the right one for your case.
Right. There are many things that we can do in every case, but not every case needs everything. And so, I know that Patricia and my firm, we try to tailor what you need to you so that you're not paying for things that you don't need, that are extraneous.
And just like you wouldn't want an orthopedic doctor operating on your heart, you don't want to pick the wrong attorney for your family law case.
Right.
If you want to settle things out of court and be amicable, don't go running around looking for that bulldog attorney. Come sit down, bring your spouse, see a mediator. And same thing, if you have a domestic violence situation, if you have a spouse that won't work with you, I've had a lot of cases where we've tried to be on that settlement track, and it gets to a place where if the other side just won't participate in the settlement process, you want to go to a litigating attorney.
Right. And that's not to say that we don't try to settle everything that we can, because the court still wants us to narrow the issues, to make sure that we're taking just those issues that can't be settled to the court. So, again, we're not blowing money just to, incur attorney's fees. We really do want to settle the things that are settlable, because when parties reach an agreement, they both buy in to that agreement.
Mistake number 3 is letting emotions get in the way of sound, rational decision. A divorce in the court's eyes is really the same as the breakup of a corporation. They're looking at what is the marital estate, and we are a community property state. And what that means is both parties have an equal right to property. So you want to look at, what is your communication? Are you, every time you speak to your spouse, are you arguing with them? You don't want to use mediation sessions to rehash old marital issues.
Right. I think that sometimes parties have a tendency to look backwards, and they want to make a record to the court of wrongs, historic wrongs, everything that their spouse has done wrong during their marriage, and to explain why they are the better person, the better parent, whatever it be. But really, the court wants the parties to focus on what's in the best interest of their children, and what can we do to separate you so that you can be, your own person moving forward.
And you want to make sure that you're not using the kids as messengers, not continuously arguing with the other parent when discussing the children, not having these arguments with the children. Don't disagree with a legal custody decision just because you're mad at your spouse. Really look at, does my kid want to play soccer? Does my kid want to do dance? And make decisions based on your children, not the anger because it was your spouse's idea and not yours.
Right, because your kids are going to see everything, and they have long memories.
Mistake number 4, not knowing when you should try mediation and when you should litigate. There are many benefits for using mediation. It's less expensive than going to court. It's private. You and your spouse are active participants. It's really focused on your children and your family rather than having a judge decide your outcome. It is important to know, though, mediation is not marriage counseling. When we're in mediation, we're focusing on the future. What's going to work for our children for the future? How do we divide our property? If you want to talk about the issues of the past, seek a marriage counselor. Seek somebody to help you move over those stumbling blocks, not necessarily to get back together, but to be able to let go and move forward. And another important note is the mediator's not going to make your decisions. I'll help show you various options for support, and I'll discuss various options for parenting plans. We'll look at scenarios for property division, but the mediator is not deciding for you. That's a huge difference between mediation and having a case heard by a judge. You and your spouse are the decision makers. You're in control of those agreements.
Right. And sometimes that's much better because a stranger in a robe isn't making decisions for your family and you know your family best. So I understand that, mediation isn't always an option. For example, if there is a history of domestic violence, maybe you just can't physically be in the same space or be on a Zoom because, of intimidation or whatever else. So um, know though that even when you litigate a case, at some point the court sets a mandatory settlement conference, which is, when they either assign a temporary settlement judge or a volunteer settlement judge where they still want you to sit down to try to reach agreement. So it is very, this concept of reaching agreements is very important to the court.
Yes. And then sometimes mediation doesn't work because one spouse just wants to litigate. The important thing to know about alternative dispute resolution, collaborative divorce, and mediation is you need to have a buy-in from both the spouses. If only one spouse needs to decide to litigate. And so if your spouse has decided to litigate, then that's when you should be speaking to a family law attorney like Elizabeth.
Thank you. Then mistake number 5 is lack of knowledge or access to support calculations and payments. So we're talking about spousal support and child support.
And spousal support is determined by many different scenarios. One of them is the length of marriage. Have you been married less than 10 years? Have you been married more than 10 years? What's the earning capacity? How much can both the parties actually go out and make if they were working? What's the income of the parties? What's the lifestyle, the age, the health of the parties? So there's a lot of different factors that go into spousal support.
Right. And then child support is a little bit more simple, which is the court programs some numbers into a program called DisoMaster or ex-spouse or the free state child support calculator. And it's basically the gross monthly income of both parties and then the timeshare parenting percentage that each party actually exercises, not what the court order is, but what they actually exercise. And there's some other things like mortgage interest or health insurance that someone pays or property tax, or is there mandatory retirement, union dues, but not much else. Clients always ask, what about my rent? Can I put that in there? No, the court considers your first obligation, your first bill due every month, your child support. So none of the things that you normally pay for are considered by the court, unfortunately.
And circumstances change in the future. You may need to go back and get things modified. If you have terminated jurisdiction, if you've said, nope, court can't make any orders, you cannot modify your support in the future. So it's important to know what that language means.
Right. And child support is always modifiable if there is a change of circumstances. Maybe someone's lost a job, someone is making more money, timeshare has changed, any of those things.
And important mistake is agreeing to waive support that you need just to avoid going to court. Really sit down, take a step back, decide, look at your budget, and if you need support it can be changed down the road. Even if you do it while you're getting on your feet and you want to support yourself. California wants you to be self-supporting, but maybe you need it for just a little bit of time.
Right. But just, what we're urging is don't throw up your hands in frustration and agree to, the other side's request that you waive spousal support or maybe even child support for a short period of time just because you're frustrated and you want to be done. Because with at least spousal support, you can't undo that waiver.
So if you want to learn more, come join us for a free divorce webinar. And so you know where to find us. We are on Divorce Town USA, Vesta, Irvine Hub. You can find us presenting the first Wednesday of every month, the second Friday of every month, the fourth Tuesday of the month, and check out our videos on demand. Thank you for joining us, for watching us today.